Hello everyone, I welcome you all to today's daily news analysis where we are going to look at important news from the Hindu as well as the Indian Express. So student, today is 25th of June and today is a very special day for those who, let's say, support the BJP, because Congress would want that we forget that dark chapter in our history, but the BJP would not allow Congress or the general public to forget that on 25th of June 50 years ago, I should say 51 years ago, a specific emergency was imposed for a specific reason, and now it is considered to be a black chapter, and it is called as a constitutional death day by the Bharatiya Janata Party. Okay, so and the first topic which we are going to discuss is with regard to the Samvidhan Hatya Divas. So today is the closure ceremony for the 50th anniversary. So last year we had the 50th anniversary. Today is the closing observance ceremony of the Samvidhan Hatya Divas, which was celebrated, which was observed, not celebrated, last year. So that would be the first topic. The second topic which we are going to discuss is with regard to that which are the documents which you can consider as a proof of citizenship in India, because now there is another executive order by the Ministry of Home Affairs, where they have clarified that passport is only a travel document. It cannot be considered as a proof of citizenship. So I think even I have to correct myself now, because earlier I used to state it in class that passport is one of the proof of citizenship, but now government is not even accepting passport as a citizenship proof now. So what exactly are the documents which are proof of citizenship? So that is going to be the second topic which we are going to discuss. Third topic which we are going to discuss is from the economics background, and this is with regard to a new index which is going to be published from the next month, and that is the index of service production. So we have discussed that we have an index of industrial production which provides us with the increase or decrease in volume or output of production in the industrial category. But now we also have a specific index which is going to give us the details of the increase or decrease in the services production. Okay, so that would be the third topic. The fourth topic which you are going to discuss is a very detailed topic. All of these topics would be discussed in very much detail, because I believe if you are doing a topic here, I don't think you should be doing it from somewhere else, because it is just a waste of time otherwise. So the next topic which we are going to discuss in detail is the new amendments to the FCRA 2010. So we are going to briefly go through FCRA 2010, which we have discussed many a times, because this has been in news all around the year. So it becomes important topic also. And then we are going to discuss in detail the new amendments which has been introduced to FCRA rules now. And then finally, the next topic and the last topic would be again from the economics background is the RBI new rules for digital compensation framework. So in case you are a victim of digital fraud, RBI has a compensation scheme for you. So what are the norms for those compensation, for getting that compensation, would be the last topic which you are going to discuss. And then yes, we are going to have those 20 plus 1 GK question. Okay, so be with me for the next session, because it is going to take a lot of time. But believe me, once we are done with these topics, I don't think you would be requiring to go through this topic at any other from any other source also. Okay, so let's look at the first topic. And yes, the comment box is open. I see a lot of comments in the comment box. Good afternoon, Devansh, Ishan. But we need to show passport in other countries, which defines our citizenship of a specific, and then how MHA. Okay, so again, what is the explanation I was going to tell you? So the explanation for why the government is not, what is the argument by government that it is not a proof of citizenship is that when you go to other country and you use your passport to showcase that you come from a specific country, that is a proof of nationality. Okay, so what the government is claiming, that passport is a proof of nationality and not citizenship now. Okay, I disagree with the government. Maybe if this goes to court, the court might disagree also. But as of now, this is the government stand, that passport is not considered a proof of citizenship now. So don't worry, we are going to discuss that currently all of the legal documents which we have, which is the document which is going to prove that if I am an Indian citizen or not. So before I make you understand the documents, which are the documents, I'll also give you the reason why these documents would be acceptable and why not. By discussing the citizenship chapters of the Constitution as well as the Citizenship Act 1955 in brief. So we are going to discuss, we are going to start the discussion with the citizenship rules, regulations, and then we are going to discuss what would be the proof of citizenship and what cannot be the proof of citizenship. Okay, so let's start with the first topic. So as you can see here, and again I found out this specific advertisement in the Indian Express where they are claiming that there is a cultural program being hosted in Delhi by the Central Government Ministry of Culture, where this would be the closing of the observance of the 50 years since the imposition of emergency. So like I said, emergency was imposed on 25th of June 1975. So last year it was the 50th anniversary, and now this year they are celebrating the they are basically observing the observance of the 50th years, closing of the observance of the 50th year of the emergency imposition in India. Okay, and what are we, how do we recognize that day now? So every year now 25th June is basically observed as a Samvidhan Hatya Divas, death of the constitution, because on 25th June 1975, when emergency was imposed in India, now we, in hindsight, we can call it that this was basically imposed on totally illegal grounds, although that was allowed under the constitution. But if we look at ethically, there was no specific ground, no proper ground on which the emergency could have been imposed in 25th June 1975. Okay, so let's understand what is the background of the imposition of emergency in that year. Then we are going to understand national emergency also. Okay, so on 25th June 1975, Prime Minister Indira Gandhi, through the President Fakhruddin Ali Ahmed, basically imposed emergency in India, and this emergency period continued for more than 21 months. Okay, so this was around there for 21 months, starting from 25th of June 75 to 21st March 1977. And yes, it is considered the most controversial period in India's democratic history, because it was believed at one point of time that democracy might even end in India if this dictatorship, or not dictatorship, if this emergency is not reversed. Okay, anyway, but that was the case on 25th of June. But why did the government, or why did Prime Minister Indira Gandhi impose emergency in 1975? So to understand the reason behind it, we have to go back 4 years ago when the 1975 general election took place. Okay, so when the Lok Sabha elections, okay, 1971 Lok Sabha election took place, basically which leads to the formation of government at the center. There were allegations against Prime Minister Indira Gandhi that she has been misusing government resources. Okay, so although you might be Prime Minister of India, but when you are contesting election, you are barred from using any kind of government resources. This can be government cars, your government vehicles, it can be your aircrafts also, your helicopters, and including your government servant services also, that cannot be utilized. Okay, however, Indira Gandhi, while she was contesting the elections from Rai Bareli, the opposition leader Raj Narayan, not the opposition leader, but people from other parties basically questioned her usage or misuse of the government resources. And when the election result was finally also announced, we know now that Indira Gandhi basically won that election from Rai Bareli, and in Indian National Congress also secured a landslide victory nationally also. Okay, so that was 1971, and that was around the India-Pakistan war also, which led to creation of Bangladesh also. Okay, but Raj Narayan, he was of the view that something illegal has happened in this election, so he basically went to the Allahabad High Court. So why did he not go to the Supreme Court? Does anyone know why did he approach the Allahabad High Court and why not the Supreme Court? If you know the answer, you can mention it in the comment box. Okay, anyway, so he went to the High Court where he challenged Indira Gandhi's election in 1975. And interestingly, the Allahabad High Court, going through the evidence, was of the view that yes, Indira Gandhi has basically misused the resources of the government, and because of this, her election is void. So Prime Minister of India has won an election from somewhere, but the Allahabad High Court said that because she had misused government resources, she is not eligible to hold the position anymore, and she has to basically resign. Okay, so her election was declared void by the Allahabad High Court on 12th of June 1975, and as per Representation of People Act of 1951, if your election is declared void because of election malpractices, then you are disqualified to contest any other election for the next 6 years. Okay, remember the 6 year was not a punishment. This is by law only. So if your election is declared void because of election malpractices, then you are disqualified to contest a election for the next 6 years. So her election was declared void and she was disqualified to be elected for the next 6 years also. Okay, and what was the political impact? So current prime minister, who was very popular at that time, especially because of the India Pakistan war, winning the India Pakistan war, was automatically, or was in a second, was declared to be not eligible to hold the post of the prime minister also. Okay, so it created a major constitutional and political crisis, that if a election of the prime minister is held void, then if she has to resign, then the government has to fall, then there has to be a new confidence motion in the house, and then a new government has to be formed. Okay, so that would be the requirement. Opposition parties demanded her resignation and nationwide protests intensified. Okay, so mind you, this judgment was given, and now we are thinking, now the next step is to be taken, whether she has to resign or not. Okay, so but because this was just the High Court, there was also an option of going to the Supreme Court. So yes, the government or Indira Gandhi went to the Supreme Court against the judgment, and now Supreme Court, I would say, yeah, we can say now that made a mistake by granting a conditional stay. Okay, so they said ki yes, she can continue as a prime minister, but she cannot go to the parliament. Okay, she would not be allowed to vote in the parliament. Her parliamentary privileges to vote in the parliament, to speak in the parliament, those would be taken away. Okay, so this is what the conditional stay provided to the then prime minister Indira Gandhi. Okay, so what does this mean? This means that Indira Gandhi could continue as a prime minister, but she could not participate in the parliament. Okay, that was the case. And now when this was allowed, the only yeah the only ethical decision which Indira Gandhi should have made was that she should have resigned from the prime ministership. However, maybe because of the recommendation, or maybe by the suggestions which were given to her by her close contacts, she basically decided that I'm not going to leave this position, because I deserve to be here, and there are certain wrong practices, wrong decision which has been taken by the Allahabad High Court. And on that basis, what she did was she declared an emergency. Not she, but she recommended declaration of emergency on 25th June 1972. Okay, so next we are going to discuss what exactly is your national emergency. But what happened on 25th June 1975 was that she proclaimed, no, the president proclaimed under Article 352 national emergency on the ground of internal disturbances. Okay, so if you would read the current constitution, you would not found this ground, because we learned from our mistake and later on we amended Article 352. But at that time in 1975, there was one of the grounds on which you could have imposed, or the government could have imposed, national emergency, and that was the ground of internal disturbances. So the process given in Article 352 is that the president is going to declare the emergency on the recommendation of the prime minister only. Okay, so if the prime minister recommends that emergency should be imposed in India, then the president has no choice but has to impose emergency in India. At least that was the norm till 1975. So prime minister Indira Gandhi recommended it to the then President Fakhruddin Ali Ahmad that you impose emergency, and President basically did what the Prime Minister told him to do. And on 25th June 1975, national emergency was imposed in India. Okay, so I hope you have understood the timeline, that how the emergency was imposed in India. Okay, now let's also understand what exactly national emergency amounts to. So if under Article 352 national emergency is imposed, what is the implication of national emergency? That is something which we need to understand. But first, let's understand what are the grounds given under Article 352 for imposition of national emergency. Okay, so what you see on the slide is the current law. So I'm going to tell you while I'm discussing all of these pointers, that what was the earlier law before 1975 and what is the current law is written on the screen also. Okay, so first thing is territorial extent of national emergency. So before emergency was imposed, national emergency could be imposed only in the whole of India. Okay, so if I wanted to impose national emergency before 1975, it could be imposed only in the whole of India. You could not impose, let's say, national emergency in only a part of India. But now, after the 42nd Constitutional Amendment Act, emergency can be imposed in whole of India also, and in any specific part of India. But remember, before 1975, it was only implementable in whole of India only. Okay. Second is, what are the grounds on the basis of which the president has the power to impose emergency? So there are three grounds right now that would be applicable if there is a threat to security or integrity of India. And what are those grounds? So those three grounds are: if there is a war with another country, if there is some kind of external aggression, it can be a state actor or a non-state actor, and third is a armed rebellion. So earlier, before, when this emergency was imposed in 1975, at that time the ground was internal disturbances. Okay, but the problem with this term internal disturbances is that it is a very vague term. What would constitute internal disturbances? So a small law and order, can it be considered? If a lot of people are on the street, are protesting against something, can it be called as internal disturbances? So what exactly is internal disturbances is a very vague term, and because of this only it was misused in 1975. But we learned from our mistake, and by the 44th Constitutional Amendment Act of 1978, this internal disturbances was replaced by armed rebellion. Okay, so now armed rebellion would be much clearer, which means when, let's say, there is a group who is trying to change the government by violent means, that would be an example of armed rebellion. Okay, so now these are the three grounds on the basis of which you can impose national emergency in India. So war, external aggression, and armed rebellion. Okay, now next is, now again we have learned it from our mistakes. So earlier, when in 1975, when emergency was imposed, there was no requirement of any kind of parliamentary approval. So if national emergency was imposed, it could continue indefinitely. However, we again learned from our mistake, and then we created a mechanism to safeguard the democracy also. So by 44th Constitutional Amendment Act, now if a emergency is imposed, there is a requirement that such a proclamation of emergency should be approved by the parliament also. Okay, should be approved by the parliament also, not just the Lok Sabha or the Rajya Sabha. It has to be approved by both the houses of the parliament, sitting separately, not together also. They have to sit separately and they have to approve the proclamation of emergency. So let's say if tomorrow Narendra Modi wants to impose emergency, and let's say the President Draupadi Murmu imposes emergency, then if let's say it is imposed on 25th of June, before 25th of July, that emergency has to be approved by the Parliament of India. Okay, so it must be approved within 1 month. That is the first condition. The second condition is that, yes, it would be requiring approval from both the houses sitting separately, which means there cannot be any kind of joint sitting. So that is the second condition if you want to approve the emergency. What is the third condition? The third condition is that the proclamation of emergency cannot be improved by simple majority. It cannot be just 50% agreeing to it. It would require a special majority. What kind of special majority? So it would require that majority of total membership of the house. So for both Lok Sabha and Rajya Sabha, whatever are the total members, majority of those would be required. But along with it, it would also require that of the members who are present that day, and have voted in the proclamation of emergency, 2/3 of those members should agree for continuation of emergency. Okay, so these are the three conditions which were introduced by the 44th Constitutional Amendment Act, and it is only after approval by the parliament that you can continue the imposition of emergency. Okay, so that is also important. Now let's say if the parliament has approved the emergency, then what would be the duration of a national emergency? So for that also we have now added a safeguard, which is that after an approval by the parliament, the emergency is not going to continue indefinitely. That emergency or that approval is only valid for the next 6 months. Okay, so let's say if on 26th of July there is a approval by the parliament that yes, you can continue with the emergency, then that emergency is only going to valid till 26th of January, when the 6 months period, 26th January of the next year, when the 6 months period is basically ending. Okay, so just remember this. So it is only for 6 months, but will it end after 6 months? So answer will be no. The requirement is that you again need to get an approval from the parliament. Okay, so again, if I repeat again the process is the president is going to proclaim the emergency. Then the requirement is that from 1 month from proclamation, you have to get it approved by the parliament. That is the requirement. These are the three conditions under which you need to get it approved. And then once it is approved, it is valid for 6 months. After 6 months, if you want to continue it, then you have to again get the approval. Okay, but by getting this regular approval, you can continue it indefinitely. Okay, do not get confused by if it is written can be extended indefinitely. It doesn't mean that requirement of approval is just for first 6 months. Okay, after every 6 months you need to get parliamentary approval. Okay, so after every 6 months you need to get parliamentary approval, and by getting regular approval of 6 months, then you can extend it indefinitely. Okay, so that would be the duration of the national emergency. Okay, next is revocation of national emergency. Again, there were also certain changes made. So how do we end the emergency? What was the process to end the emergency? So before 1978, I should say not 75, before 1978, when the 44 Constitutional Amendment Act was made and certain changes were made, certain safeguards were introduced in the constitution. Before that, there was only one way by which national emergency could be revoked, and that was by a revocation by the president. Okay, by a revocation order by the president. It could simply be removed whenever the president is of the view. Usually he works on the recommendation of the prime minister only. So if the prime minister recommends to the president that now you should end the emergency, then the president could revoke the emergency. Okay, however, by the 44th Constitutional Amendment Act, we have added another safeguard, and this time it is the Lok Sabha which has been given this safeguard. And the safeguard is that if 1/10 of the members of the Lok Sabha, not the 50%, not 100%, if 1/10 of the members of the Lok Sabha write to the Lok Sabha speaker that we want a discussion on emergency, then there should be a discussion, and that discussion should take place within 14 days. And if there the Lok Sabha comes together and decides that the emergency should be revoked, in that case the emergency can be revoked at any time. Okay, so it is not necessary that just after emergency you have to do so. Let's say emergency is in its third month, fourth month, or let's say in the second year, third year. Whenever, let's say, if 1/10 members of the Lok Sabha go to the Lok Sabha speaker asking for a sitting of the Lok Sabha, then within the next 14 days there is a requirement of doing a sitting, and then if in that case Lok Sabha passes a resolution revoking the national emergency, then the Lok Sabha has a right to revoke the emergency also. Okay, so this is how your national emergency can be revoked. So what we have understood, what are the grounds, what is the duration, what are the conditions, and what is the process of revocation of emergency. Now, what about judicial review of emergency? What do you think? Can the Supreme Court or High Court, can they review emergency in India? So during the imposition of the national emergency in 1975, a constitutional amendment was made. Okay, that was a 38th Constitutional Amendment, and it was done for a single purpose, that they wanted that no emergency proclamation can be questioned in the court of law, which basically means that by 38th Constitutional Amendment Act, the intention of the parliament was to remove the judicial review of emergency. Okay, which means for 1975 emergency, there was no power to judicially review that emergency. Okay. However, we again learned from our mistake, and again by the 44th Constitutional Amendment Act of 1978, the Parliament made the emergency judicially reviewable, which means now the condition is, or now the situation is, that emergency can be judicially reviewed also. Okay. So this has also been clarified by the Parliament by 44th Constitutional Amendment Act. Okay, now let's understand. So this is how your particular national emergency is imposed, and that is how it can be revoked, and these were the safeguards which were added later on. Okay, now what I've done is I've basically compiled whatever amendment were made to safeguard our democracy from any future imposition of national emergency on certain grounds. Okay, and everything was done under the 44th Constitutional Amendment Act of 1978. Okay, what was the first thing which we did? So first thing what we did was that we limited the grounds of imposition. We removed the ground of internal disturbances and replaced it with the ground of armed rebellion, which is much more specific. Okay, second is, which is also very important, like you remember, the 1975 emergency was imposed by president on the recommendation of the prime minister only. So what we did was we changed the language of the recommendation, and we said that now there would be a requirement of a written advice. Okay, there has to be a written recommendation to the president, and not just by the prime minister but by the cabinet. Okay, So the word cabinet, which is basically a term used for the senior ministers of the senior council of ministers, the major ministries holders. So the cabinet is going to give a written advice to the president, then only you can impose national emergency. So that was the second condition which was put. What was the third condition? Third condition or third thing which was changed was that it restored judicial review, which was removed by 30th Constitutional Amendment Act. Okay. Next, very important thing which we did, which they did was that when there is imposition of national emergency, even your fundamental rights were suspended. However, one change was made, and the change was that Article 20 and 21 could not be removed, could not be suspended even during imposition of emergency, and that is a very important protection of your fundamental rights. Okay, next is reduce chances of arbitrary emergency proclamation. So again, by these safeguards, what we have done is we have reduced chances of arbitrary imposition of emergency in India. And by this, by protecting Article 20 and 21, by restoring judicial review, what we have done is we have strengthened civil liberties and democratic safeguards. Okay, so these were some of the safeguards which we learned from our mistake, and then we decided that these safeguards would be enough to not arbitrarily impose any kind of national emergency in India. Okay, apart from it, something which is very important for a law student to know is some of the very important case laws which were decided by the Supreme Court, one during the emergency and one after the emergency, or two after the emergency. Okay, one is a very famous case of ADM Jabalpur versus Shivkant Shukla. That is a very important law, and this was passed during the tenure of emergency. So this was passed during tenure of emergency, and it is one of the most criticized judgment of the Supreme Court. Okay, heavily criticized judgment of the Supreme Court, because the Supreme Court said that suspension of remedies, which means that the right of you to move to the Supreme Court or High Court for violation of your fundamental right, is also suspended. Your Article 32 and 226 are also suspended during emergency. Okay, which means during emergency, the government has the power to do or has the right to do whatever they want to do. Okay, and that is what the Supreme Court said in the ADM Jabalpur case, which basically meant that during emergency you do not have any kind of judicial remedy. If there is a preventive detention, if the police has put you in a lockup without giving any reason, you have no remedy against the police or the government. That is what your fate tells you. Okay, so that was the ADM Jabalpur during emergency. Like I said, it was heavily criticized. However, there was a course correction once emergency was removed, and that was done by the Maneka Gandhi case versus Union of India. Okay, so it's one of the most important cases related to Article 21, because in ADM Jabalpur, the court interpreted Article 21 to say that if there is a procedure established by law, if a procedure exists, it can be any kind of procedure. It doesn't matter if the law is fair or not. Such a law can be created and a person's life and liberty can be taken away. Okay. However, in Maneka Gandhi, the Supreme Court did a course correction, and then it changed the interpretation of procedure established by law. Okay. So in Maneka Gandhi, what did the court said? That the procedure established by law used in Article 21 is not just limited to the procedure, but it also relates to the substantial part of the law also. And the court said that procedure established by law means that the law itself should be fair, just, fair and reasonable. Okay. So what did the court said? That the parliament does not have the power to create all kind of law. Okay, it doesn't mean that just because parliament has created a law, they can take away your fundamental rights also. The court clarified here that whenever there would be a judicial review of any law passed by the parliament, it would not just check whether proper procedure has been followed or not, but it is also going to check whether the law in itself is just, fair and reasonable. Okay, which means if now parliament want to make some draconian law where they want to take away your power of judicial review, your power of challenging it in the court of law, then such a law cannot be created, because the court is going to cross check whether the law itself is just, fair or reasonable. Which means now the court has did a course correction, and now your personal liberty would also be protected now. Okay. Similarly, in Minerva Mills versus Union of India, again in 1980, the Supreme Court decided that emergency proclamation can be challenged. Okay, so in 1980, it was also again clarified, although by 44th Amendment, the Parliament also restored judicial review. But in Minerva Mill case also, the Supreme Court clarified that be it national emergency, state emergency or financial emergency, an emergency proclamation can be challenged if it is proved or if it is shown that it is based on malafide, it is based on irrelevant consideration, or the proclamation itself is arbitrary or perverse. Okay, so Maneka Gandhi, which is a very important case law with regard to Article 21. Similarly, Minerva Wills is another very important case with regard to basic structure doctrine, as well as the power of the Supreme Court to judicially review emergency if there is grounds of malafide, irrelevant consideration, or the proclamation itself is arbitrary or perverse. Okay, so that is what the Supreme Court said in Minerva Wills case. Okay, and finally, if someone asks you that yes, you have a provision of national emergency, but how many times national emergency has been imposed in India? So there have been, as of now till 2026, there have been just 3 instances when national emergency was imposed in India. Out of these 3, 2 were legally imposed, and that was because of war or external aggression, and those were the 1962 and 1971 war. So during the India-China war of 1962, national emergency was imposed on the grounds of external aggression, and in 1971 again it was imposed because of India-Pakistan war because of external aggression. But the next one, which is the most controversial and is the topic at hand, is the 1975 emergency of 21 months, which was imposed on the grounds of internal disturbances, and then we realize that that is a very vague ground, and we change it to the ground of armed rebellion now. Okay, so that is what is the history of your Samvidhan Hatya Divas now. Okay, so that was the first topic, and I think we have covered it very thoroughly, so I don't think you would be requiring any other class for national emergency now. Okay. Okay, any election petition should be filed under High Court, not Supreme Court. Good. Yes, Joya, you are correct, totally correct. So the reason why Raj Narayan approached the High Court was that under Representation of People Act, it is given any kind of election petition which can be filed only once the election process is complete, can be done only in the High Court. Okay, so he was correct to go to the High Court as the forum for election dispute. Okay, so that was a really good answer. Okay, moving on to the next one. Okay, now let's move to the next topic. Again, a very important topic. And now what the Supreme Court has, not the Supreme Court, what the government has said is that passport is a travel document only. It is not a proof of citizenship. Okay, so this is also very important clarification given by the Ministry of External Affairs. Okay, it is by the Ministry of External Affairs because that is the body, that is the department or the ministry which provides you with the passport. Now, what the Ministry of External Affairs has clarified is that passport, which we used to consider to be proof of citizenship, because if you look at the passport first page also, it has a stamp of the central government. Okay, but now what they are saying is that even passport cannot be considered as a proof of Indian citizenship. Okay, so first let's understand what is the law of citizenship in India, and then we are going to discuss the different documents which can be used as proof of citizenship and which cannot be used as a proof of citizenship. Okay, so first thing first, if you want to understand the law of citizenship in India, first you need to go to the constitution itself. So part 2 of the constitution, which consists of article 5 to 11, provides who would be citizen of India at the time of implementation of the constitution. So starting from 26 January 1950, who can be citizen of India, who cannot be citizen of India is given in the constitution itself, and it clarifies under article 10 and 11 that the future laws of acquisition and revocation of citizenship would be created by the parliament. Okay, so that is what the constitution says, and yes, on the basis of article 10 and 11, the Parliament has created a Citizenship Act of 1955, which has been amended from time to time, and the rules of citizenship are given there only. Okay, but let's first understand in very basic what does the constitution talks about the citizenship law of India. Okay, so first article which you are going to read with regard to citizenship is article 5, which basically says that a person becomes a citizen of India on the Republic Day, on the first Republic Day, 26 January 1950, if he or she has domicile in India, which means he or she has the intention to live in India, and which means this is one condition which is compulsory, and there is a second condition also attached, which is he or she was born in India, or either parent was born in India or had been ordinary resident in India for at least 5 years before this specific date. Okay, so you have to fulfill the first condition, and you have to fulfill either of the second, either of these three conditions, that either you should be born in India and should have the domicile of India, and or your parents should be born, either of the parents should be born in India, or you should have been ordinary resident at least for the last 5 years in India, and you should have the intention to stay in India. Okay, and that is what Article 5 talks about. Okay, then there is Article 6, 7, 8, which clarifies if you have moved to Pakistan, if you have come back to Pakistan, what would be your status of citizenship. So we are not discussing those because they have become irrelevant now. Okay, so this is something which you should study in your polity class. Just go through your polity documents, and you would find what does Article 6, 7, 8, 9 talks about. 6, 7 talks about. Now let's move to the next article, which is of interest to us, which is Article 8. Okay, what about person of Indian origin? Okay, so you must have heard the term NRIs, non-residential Indians. So NRI is a term which is specifically created for taxation purposes. If you would read the constitution, you would never nowhere read the term NRI. You would read a term which is called as PIOs, person of Indian origin. Okay, so person of Indian origin is a person who or whose parents or whose grandparents at some point of time would have been eligible to be Indian citizen, but now they are residing abroad. Okay, so it might be because of colonization that they were taken away as laborers, forced laborers to different countries as Girmitiyas laborers. They have been taken away. So their wards, their next generation are eligible to get Indian citizenship in India by process of registration. Okay, so what they, if they want Indian citizenship, what they need to do is they need to go to the Indian embassy in their country, and they have to get registered there as a Indian citizen, and they can easily get Indian citizen also. Okay, now again, Article 8 is not that relevant for us because everything is now decided as per the Citizenship Act of 1955. Okay. Next is Article 19, which simply says that in case you have acquired citizenship of some foreign country, so let's say if you have become citizen of Pakistan or let's say US, then you automatically have renounced your citizenship of India. Okay, which means you cease to be Indian citizen and now you are citizen of some other country. What is the implication of Article 9? Article 19 implies that in India we do not have dual citizenship. Okay, so that is the implication. If someone asks you, how can you say that India does not recognize dual citizenship? So you have to show him Article 9, which says that if you have acquired citizenship of any other country, your Indian citizenship ends then and there. Okay, so this is what the constitution talks about, and I've already told you. Article 1011 simply says that future law of citizenship is to be created by the parliament now. Okay, and parliament has created Citizenship Act of 1955, which has been amended time and again to change the rules of citizenship. Okay, so if you would read Citizenship Act of 1955, which was most recently amended in 2019 only to provide citizenship to people of neighboring countries of Afghanistan, Pakistan, Bangladesh. Okay, so this Citizenship Act of 1955 provides what are the modes of acquiring citizenship, how all you can acquire citizenship. So there are five ways in which you can become citizen of India. First is if you are born in India. Okay, if you are born in India, but what if your parents are foreigners? So then in that case, even by birth, you would not be acquiring citizenship. Okay, so unlike US, where even if your parents are illegal immigrants, but you have been born on the soil of USA, then you would be given US citizenship. Okay, but that is not the case in India. In case if you are born in India, one of your parent needs to be an Indian citizen and the other cannot be an illegal immigrant. That is the condition which was added in 2003. Okay, so by birth would not be enough. One of your parent needs to be Indian citizen and the other should not be an illegal immigrant. Then you are eligible for Indian citizenship. The second is by descent. By descent simply means if your parents or grandparents are Indian citizen and let's say you are abroad, then you can simply get Indian citizenship by registering. Okay, then third is your category of registration only, which is for person of Indian origin, which is given in Article 8. Okay, so Article 8 is implemented by this process, registration process. So what you need to do is, let's say if you are out of India, or let's say if you are in India, you need to go to the nearby embassy of your country, wherever you are residing, Indian embassy, and there, if you are person of Indian origin, if you are person married to Indian citizen, if you are minor children of Indian citizens, so let's say your parents are in USA and you were born there, If they want that you should be Indian citizen, you have to go to the nearby embassy and you have to get registered yourself as an Indian citizen. And if you are overseas Indian meeting statutory condition, so certain conditions are there. If you meet those conditions, then you can become Indian citizen by simply getting registered also. Okay, but what about if a foreign citizen or a foreign country person wants to become citizen of India? In that case, there is a proper process called as the naturalization process. So what are the conditions of naturalization? We are not covering it right now because that is again a separate topic in itself. So if naturalization would be news, we are going to discuss it. Otherwise, not relevant for GK right now. But let's say if a foreign citizen wants to become India, then he has to fulfill the conditions of naturalization. And finally, the fifth condition by which you automatically a foreign citizen or a foreign countryman can become an Indian citizen is if their territory is incorporated into India. Okay, so simply if I give you example, let's say tomorrow Pakistan becomes part of India, all the citizens of Pakistan would automatically become citizens of India. Okay, and we have two real examples also. For example, Goa, which was a Portuguese colony. Okay, Goa, which was a Portuguese colony, and Sikkim, which was a protectorate earlier, was a monarchy. Both of them became part of India in 71-75, and all the citizens of Goa and Sikkim, okay, which were not early citizens of India, automatically become citizens of India also. Okay, so this is how you become citizen of India. Okay, what about loss of citizenship? Can you lose your citizenship also? Yes, it is possible. There are three ways in which you can lose your citizenship. One is renunciation, one is termination, and one is deprivation. Okay, so what do you understand by deprivation? Renunciation, terminations are self-explanatory. What is deprivation? Deprivation is if you had done any kind of fraud in obtaining citizenship, if you have shown disloyalty to the constitution, and if you were held guilty, you were involved in certain serious offences. In that case, if you were earlier a foreign citizen and now have taken up Indian citizenship, or if you were earlier foreign citizen and now you have registered as Indian citizen, then in that case, these can be the grounds by which you can be deprived of your citizenship. Okay, so these are the three conditions. Okay, so now we have understood the basic of citizenship. Now let's understand the topic at issue, which is what are the proofs of citizenship, because as per the government right now, even passport cannot be considered as a proof of citizenship. Okay, but let's start with the very basic. So first thing first, that as of now there is no universal citizenship certificate. Okay, so you and I, we can claim that we are Indian citizens, but we actually do not have a single proof of citizenship as of now. Okay, because there is no such certificate which says that we are citizens of India. The government does not provide such kind of certificates to all the citizens. It is provided to some. We'll see which class of people are provided with this certificate, but we as citizens of India do not have that certificate. Okay, now let's look at what are the commonly used document as evidence of citizenship. Okay, first, which is considered to be kind of a full proof of that you are an Indian citizenship, if you are an Indian citizen, is your birth certificate. Okay, so if you have a birth certificate issued by the concerned authorities of India, then you can claim that you are citizenship by birth. You are citizen of India by birth only. Okay, but again I've already clarified it that the requirement is, because now after 2003 the requirement is that one of your parent needs to be citizen of India and the other should not be illegal immigrant. So in case there is doubt about your parents, if there is a doubt about citizenship of their parents, then even birth certificate can be questioned. Okay, second is your citizenship certificate. Okay, like I said, citizenship certificate is not issued to all the citizens of India, but it is issued to a class of citizens of India. Who are those people? So they are people who have acquired the citizenship through registration or nationalization. Okay, so if you go and register yourself as Indian citizen, or after by the process of nationalization you have become Indian citizen, then you would get a citizenship certificate. This would be obviously a full proof for your citizenship. Okay, so that is that first two evidence. Now let's look at the next evidence, which I am also shocked that now the government has said that passport would also not be considered a proof of citizenship. It can be considered a proof of nationality for foreign countries, and it is only a travel document. Okay, it is primarily a travel document. It certifies nationality for international travel. It is not by itself a conclusive proof of citizenship for all legal purposes. Okay, and do you know why the Ministry of External Affairs has made this clarification? Because if you remember the topic of SIR, special intensive revision being done in West Bengal, Tamil Nadu, and in case of West Bengal, so many people are in the doubtful voter list. Okay, so now they have to prove their citizenship. So some of the people were showcasing their passport as a proof of citizenship. So now External Affairs has clarified that the passport is not the proof of citizenship for all legal purposes. Specifically, what they want to say is that if your name was excluded from the voter list, you cannot use passport as a proof of citizenship. Okay, so that is why the Ministry of External Affairs has made this clarification. Okay, so now even passport is not a proof of citizenship. So citizenship certificate we don't have, passport is not the proof of citizenship. Birth certificate can also be cautioned. Let's look at the next one. It is your electoral roll. Okay, now we know this, that inclusion in Indian electoral rolls indicates recognition as an Indian citizen for electoral purposes only. Okay, so now the problem is that after this SIR exercise, even if your name was there in the earlier electoral roll, it does not guarantees that your name would be in the next electoral roll, which means we are not even sure that even electoral roll, which allows me to, let's say, vote in the political elections of India, that is also not even considered as a proof of citizenship in India. Okay, so that is also really important, that even electoral roll or your name in the voter list is also not a proof of citizenship of India. Okay, forget about you having a epic card also. Next, Aadhaar card. So we are already clear about this, that even it is written on your Aadhaar card. So if you have your Aadhaar card with you, just check it. There is a specific line written in a box which is that it is not a proof of citizenship. So the government is so clear with regard to Aadhaar status that they mention it there that it is not a proof of citizenship. It is only a proof of identity and your residence. Okay, so residence can be temporary. Even a foreign citizen can have a residence in India, right? So but that is not a proof of citizenship. So Aadhaar card is also not a proof of citizenship. Next is your PAN card. Again, be very clear, PAN card is only a taxation document, and even a foreign citizen can get a PAN card in India, because government is only concerned about taking taxes from the people. They don't care if we are citizen of India or not. Okay, so PAN card is also not a proof of citizenship. Next is domicile certificate. Okay, it establishes what is a domicile certificate. Domicile certificate is only an intention that you come or you reside, you intend to reside at a specific place. Again, this is also not a proof of citizenship. Okay, so we have a list of 7 documents as of now, and none of this is a short evidence of citizenship except for citizenship certificate, which is given to only a very small class of people. Okay, next is government service records. Okay, so let's say you there are different government service records in electricity bill, water bill, different kind of services you might have taken at some point of time. So your name would be there in those records. So again, this can be used as a supporting evidence to, let's say, to prove your citizenship. Let's say by electoral roll, you can be using some government service record also, but that is again not a conclusive proof. So this is also not a proof. Next is your land and ancestral records. Okay, again, land and ancestral record is again just a supporting document. Let's say your birth certificate says that you were born in India, but if there is some doubt with regard to your parents' citizenship, then you can use the land and ancestral records, your family lineage records, to showcase that yes, your parents were also Indian citizens only. Okay, which means out of these 9 documents, none of these are proof of citizenship. Okay, which means as of now, what would be, if there is a question, which of the following can be considered as a proof of citizenship? The answer would be none of the above. Okay, none of the above. Nota would be the answer for any of these documents if they are there. Yes, if it shares citizenship certificate, that is a conclusive proof of the of citizenship in India. But apart from it, no document which all citizens of India have can be considered to be a conclusive proof of citizenship in India as of now. Okay, let's see if some new evidence or new document is introduced, but as of now, none of these documents are can be considered evidence for citizenship proof of India. Okay, so this is with regard to your citizenship. Okay, so I see a lot of questions you have asked. Okay, so NRI, OCI plus PIO. Yes, OCI plus PIOs and NRI, all of these would be examples of person of Indian origin only. Again, OCI or NRI are also not mentioned in the constitution. The term used there is PI only. Yes, 27.16 lakh voters were deleted. Yes, exactly. And that's why now, because the government doesn't want, government had made it a big, had made a huge hue and cry that lot of illegal immigrants have entered into West Bengal, and because of this, they were not able to win elections. So to prove them correct, now they are claiming that even your passport would not be a conclusive proof of citizenship. Just as we travel from one city to another city with a ticket, the same we will travel from India to another country through passport, indicating that we made our departure from India. Yes, Ishan. So you can just simply claim, like the government is saying, that it is only a travel document. It is just going to show that you are currently a national of India. Okay. Now the thing is, what is the meaning of that I am a national of India? Okay. Isn't, if all the countries, if internationally passport is considered a proof of citizenship, how can India's Ministry of External Affairs claim that it is not a proof of Indian citizenship? Okay, so sir, if none of the documents is a proof of citizenship, then how can I call citizen of India legally or documentally? Okay, so yes, this is a worrying thing. And actually, when I was a student, I asked it from my teacher that what is there some document which can prove that I am a citizen of India? And at that time, he told me, this is like 10 years ago, and he told me that if your name is in the voter list, if you have a voter ID card, if you have a passport, all of these would be proof of citizenship. Okay, but even now, he would be wrong looking at the clarification which has come from the government. So currently, if the government want to question my citizenship, now the burden of proof is on me to show that I am the citizen of India. Okay, because there is no single document which can conclusively prove that I am a citizen of India. Okay, and this is not a good sign for a healthy democracy, that the government can question my citizenship at any point of time. Okay, this is not good for a vibrant democracy, because now it is in the hands of the government to decide who is going to be citizen of India or who is not going to be citizen of India. Okay, so let's say if you don't agree with the government can simply claim that you are not even a citizen of India, you are a foreign citizen. So let's say if someone is arguing against the government, and let's say there is some doubt with regard to his or her citizenship, then the government would caution their citizenship first. Okay, and then they are going to call you foreign agent, and then you would be sent into jail or sent out of India also. Okay, and this has happened with some of the social activists also. So this is not good for the health of our vibrant democracy also. Okay. Okay, so this is with regard to it. Then we will renounce the world that we are born in India after 20 and our parents are Indian, we are ordinary citizens. Yes, you can say so. Okay. So now let's move to the next one. Again, very important topic for CLAT, ALET or any other examination you are targeting in this year, because now a new index has been introduced for the first time in the history of India, and that is Index of Service Production. Okay, so this is a totally new index. No such index ever existed in India, where we were measuring the output of the service industries, okay, or the services sector. But now there is a specific index which is going to give us monthly data of the output or volume of production of services in India. Okay, who's going to publish this specific index? So this is going to be published or introduced by the Ministry of Statistics and Program Implementation. So MOSPI is going to come up with the index of services production. So what would be the regularity of this? So this would be a monthly index, okay, monthly statistical indicator that would give us the change in the volume of output, okay, not the value, not the monetary term, but the volume of output of services produced by various service sector activities in the economy. Now, what I don't understand is, because maybe my understanding is limited, but how would you measure the volume of services? Okay, because in goods there can be a measurement that this much kgs or this much liter is the production, but I don't know what would be the measurement of volume of output in this. Okay, so more clarification would come later on, so then we would have a clarity about it. But here also, just like index of industrial production for industries, there would be a measurement of volume of output of various services in India. Okay, so here it is also mentioned that it would be a counter to the index of industrial production, which measures industrial production, and this would measure the service production. Okay, and now we have a base year also, because this has been introduced just now only. So base year which we are going to use is going to be the base year of 24-25. So last financial year would be the base year, would be used as the base year. Okay, and this would not be up to date either, it would not be very latest. There would be a time lag also. So there would be a time lag of 60 days. Okay, so if the first ISP is going to be released in July, so if it is being released in July for the month of June, May, so it would be for April. Okay, so for the month of April, you would be getting the data in June, and not even June, in July actually. Okay, so release schedule, first release ISP for April will be released on 14th of July. Okay, this would be released on 14th of July. So yes, there is a delay of 15 days because we are doing it for the first time. But for the month of May, it would come in on 29th of July. Okay, so the next set of data would come from 29th of every month. If 29th is a holiday, this would be given release on the next working day. Okay, and this has been now clarified that there would be a lag of 60 days. So, but the first ISP would be released on 14th of July. So this date is also important. The first month for which we would have the ISP data would be the month of April in 2026. Okay, now who has developed this ISP? Who had developed the methodology? The measurement mechanisms for this. So this has been developed by a technical advisory committee, which was headed by Devjani Ghosh. Okay, Devjani Ghosh chaired technical advisory committee, has developed the index of service production. Okay, so this is also a very important news as compared to the previous news item. In very short we have done it, but like it is also very important. Okay, now let's move to the next topic. Again, we have to do it in detail because again, this is a very important topic. Again, FCRA has been in news all around the year. So that's why this becomes important news for all of us. Okay, and I'm sure you must have covered it yesterday also. So again, for those who covered it yesterday, this would be a kind of a revision, but I would be adding 1 or 2 Supreme Court cases also, because that is what I found in the Hindu newspaper. Okay, so from the Indian Express, this is the news. So I'm sure you are aware that the Foreign Contribution Regulation Act, which regulates donations by foreign entities into Indian NGOs, trusts and other bodies, is the primary law for foreign contribution. Okay, so there are new rules introduced in the year 2026, which are called as FCRA rules, and what it has done is it has made it stricter for foreign contribution to come into India. Okay, so who administered FCRA? So it is administered by Ministry of Home Affairs. Okay, so what is FCRA? Like I said, it is a law to regulate acceptance and utilization of foreign contribution and foreign hospitality by individuals, association, NGO and companies. Okay, now if you would read FCRA says that in India you can give foreign contribution or you can get foreign contribution only for specific categories. So if you are an NGO, association or a trust working for social works or social objective, then you can get funding in India. If you are doing economic work, educational work, cultural work or religious work, so you just have to mention that these are the purposes for which you are getting money, foreign contribution into India. Okay, so that is the FCRA. But what I'm more interested in, what are the major amendments introduced in 2026? Okay, first is now there is a purpose-based restriction on the restrictions on the grounds on which you can basically take foreign contribution. Okay, so earlier what was the requirement? If let's say you are an NGO and you wanted foreign contribution, you have to just register as a social, economic, education, culture or religious category. Okay, but now you need to have registration certificate for exact purposes for which you are going to use. Okay, so it would not just be social, economic, there would be specific categories of social work, educational work, economic work for which you can get foreign contribution, and around 105 approved activities have been given in a schedule. Okay, so now you just now it would not be enough if you just mention that you are doing social work. What category of social work you are doing? So there are 105 approved activities which you need to choose from. Okay, and we will read later on also, there is another point that there has to be a fee paid for all kind of registration work you are doing. Okay, or kind of activities you are doing. So if you are doing 2 approved activities, you have to pay 2 separate registration fees for those 2 activities. So if you are doing 105, you have to pay 105 times the registration fees. Okay, and foreign funds can only be used for the approved activities listed in the registration certificate. So let's say if you have said that I'm going to do these 3 kind of social work and this 1 kind of educational work, you could use your foreign contribution only for those 4 kind of registered activity. Okay, so somehow they're trying to limit the influence of foreign money in the Indian polity. Okay, second is there is a geographical restriction also now. So now there is a purpose based restriction, and second is there is a geographical based restriction also. What do you mean by geographical restriction? So let's say if you are a NGO registered in India in any state and you were working in, let's say, just state of Rajasthan, and you were not working in MP. So you just need to inform that now you are going to work in MP also. But now the new requirement is that you have to specify in which state and UTs you are going to function. And again, if you use your funds outside of this, then this would be a illegal act, which means if you have registered yourself in, let's say, Rajasthan, MP and Chhattisgarh and not registered, let's say, in Jharkhand, then you cannot use your foreign funding or you cannot do your activities in the state of Jharkhand. Okay, if you are using foreign funds, okay, only then. Okay, any expansion into new states will require fresh approval from the government. So let's say if now you want to move into Jharkhand also, if you want to do activities in Jharkhand also, that would require that you take fresh approval from the government. Okay, existing FCR registration organization have 1 year to align their registration with the new framework. Okay, so if you are already an NGO, then also you have to comply with these requirements now, and you will be given a 1 year time to follow all the new registration. Okay, third is mandatory disclosure requirement. So earlier you had to just declare your financial details, but now you have to declare all of these also. So you have to submit a detailed activity report every year. You have to report or disclose what all websites you are using, what all social media accounts you are using. Are you doing any kind of publications, like are you publishing some kind of books, magazines, articles? All of this has to be given to the concerned authorities under MHA, and you have to give information regarding ultimate donors also. Okay, so let's say if you are getting some amount, some donations from X company. Okay, X company. So, but X company is, let's say, it is a subsidiary of a Y company. So you have to disclose who is the ultimate donor in this specific case. Okay, so that is also one of the condition. Next is broader definition of key functionaries. Okay, so key functionaries are given, there are more regulations for a key functionary person. So earlier it was only for the directors or CEO, the main office bearers of the company, but now it includes the trustees, partners, directors, members of governing bodies, office bearers, karta or head of a HUF if they have also created a NGO or a trust, any person exercising control over management or affairs of the organization. Okay, so even the definition of key functionaries has also has been broadened in this specific law. Next is restrictions on foreign nationals in leadership positions. Okay, so this another condition has been added. So if you are, let's say, running an NGO or some association or trust which is getting foreign contribution, now as per the new rules, no foreign national can be a key functionary in your body. Okay, they cannot function as a key functionary, which means they cannot be any of this trustee, partner, director, etc., etc., etc. Okay. So can be approved only through specific government permission. So yes, they can be, but you would be requiring government permission. Okay, and PIO does not include foreign nationals. Okay, next is specifically to deal with religious activities. The Supreme Court, sorry, the Ministry of Home Affairs under the rules has banned all kind of proselytization through foreign funding. Okay, so religious conversion activities are allowed in India. They are not totally illegal. Only forceful conversions are prohibited in India. Okay, proselytization basically means that you are trying to convince others to change to your religion. Okay, so now if you are an NGO or some organization or trust which is getting foreign contribution, then you cannot be using that money for proselytization activities. So yes, you can get funds for religious activities, but you cannot use for proselytization activities. Okay, so now again go back to the point, like I said, that earlier you only had to register for let's say religious activities, but now these kind of religious activities would be given. For example, religious education, satsang, discourse, meditation program. So these would be these are some of the examples of 105 approved categories now. So let's say if you want to work for religious education and satsang only, then you have to register for these two separately, and you have to pay a fees also. Okay, next is political activities. They have also been restricted. Okay, now they say that only certain activities would be approved if you are getting foreign contribution. And for example, if you are into awareness, if you want to run a awareness program on constitution rights, fundamental duties, civil responsibility, then you cannot be of a political nature. You have to be a non-political awareness program. Okay, so this cannot be targeting any political party. Next is separate fees has been introduced. So earlier there was a single registration fees, like I said. Now you need to pay separate fees for each approved purpose, each state or UT of operation. So you can see here that if you are getting foreign contribution, it is going to be a costly affair. It is going to be really costly affair. And this, what would this basically do is that most of these NGOs, trust, association would not be inclined to get foreign donations, simply because it is going to be very hard to get foreign donations now. Okay, next is minimum utilization requirement. So there is a minimum utilization threshold for foreign contribution, which means ki whatever money you are getting, there would be a requirement that this, let's say if you are getting 1 lakh rupees, you have to spend 80,000 to 90,000 for your general activities only. You cannot use it for other purposes. Okay, so these kind of conditions would also be required. This would influence renewal or registration and cancellation decisions also, which basically means that if you don't follow this, then it can lead to this also. Okay, and finally a new penalty framework has also been introduced. What is the new penalty framework? So in case you now violate FCRA provision, now in most cases there is a penalty of 1 lakh of minimum. Okay, minimum 1 lakh penalty would be imposed on you in most cases, or it could be a percentage of the funding which you have received. So that can also be one of the penalty which can be imposed on you. Okay, so this is the addition which I wanted to do. Like, there was this article, Supreme Court had agreed the right to associate, which is a fundamental right, is not carte blanche for foreign brands. Okay, carte blanche basically means that it doesn't mean ki you get absolute right to get foreign funding if you just because you have the right to associate. So the Supreme Court, I would quote two important judgments, recent judgment of the Supreme Court. One is a very recent case of Noel Harper vs. Union of India, where Supreme Court upheld the validity of FCR amendment. It said that just because you have the fundamental right to associate, it does not mean that you have the right to get foreign contributions also. Okay, it does not automatically include the right to receive foreign funding, and no organization has a vested or absolute right to receive foreign contribution. Okay, so there is no right to get foreign contribution, which means if the government wants, it can totally limit your right to get foreign contribution. Okay, second is another case, INSAF versus Union of India, Indian Social Action Forum. Nice acronym, INSAF versus Union of India of 2020. It says regulation of foreign contribution is necessary for protecting national interest. So for national interest, you can regulate foreign contribution. Only organization involved in active political activity should be restricted. A balance must be maintained between regulation and the freedom of voluntary organization. So here the court was much more liberal. It wanted that yes, we understand that national interest needs to be protected. There has to be a balance, but only there should be more restriction on the active political activities. But for other activities, there should not be such kind of restrictions on receiving foreign contribution. Okay, but the more important is 2022, which is basically stating that your right to get foreign contribution is not absolute, and the government can restrict it also. Okay. Now let's move to the last news for today, which is again very important for someone. If let's say you are someone who has been a victim of cyber fraud, so RBI has come up with a scheme. So in case there is some kind of digital fraud to you, okay, so you were doing some electronic banking transaction. What do you understand by electronic banking transaction? For example, you are doing a transaction through internet banking, debit card, credit card, you are doing a UPI payment, internet banking, mobile banking. Okay, or any other method you are using for doing electronic transaction, and because of one of these reasons, because of negligence by the bank, because of the third party security breaches, so you were trying to make a payment on, let's say, Flipkart or Amazon, and because someone has hacked into their account, that's why you were the victim of a digital fraud. Or let's say there was some fraudulent digital transaction, and this can be because of your stupidity also. So in that case, there is a compensation mechanism now. Okay, and why this compensation mechanism has been given, even though you might have been negligent or you might have done some kind of stupid act, because we want to build a trust in electronic transactions. Okay, so there should be some trust in the electronic transfer So some compensation is given to you, and customer will be eligible for compensation if the loss arises from a fraudulent electronic banking transaction, fraudulent EBT. If some fraudulent activity has taken place, the customer is a bona fide victim of fraud, which means you were not someone who was indirectly involved into it, and the gross loss is up to 50,000. Okay, so not 5 lakh, you don't have any remedy. So if your loss is of up to 50,000, then you are eligible to get some compensation under this RBI scheme. And the one of the thing which you need to do is you have to report it within the prescribed time limit. What is the time limit? The time limit is 5 days. Okay, now what is the amount of compensation? So let's say if you have faced a loss of 30,000 rupees, so in that case 85% of the net loss, not the 100%, you will be given 85% of the net loss amount, or 25,000, whichever is lower. Okay, so lower amount would be given. Okay, and this 85% loss is to be bore by these specific banks. Okay, so first is your RBI, which is going to bear the 65% of the compensation. 10% is to be bore by the customer bank, and 10% by the beneficiary bank. Okay, so let's say there must be some other bank also which was on the other side, which has received the amount. In that case, 10% by the beneficiary bank, 10% by the customer bank, and 65% by the RBI would be given to you as a compensation. Okay, however, there is one important condition, and the condition is that you can avail this benefit once during the customer's lifetime. Okay, so in your lifetime you can only get this benefit, this compensation, only once. Okay, it is not like if you are getting it, you are getting into if you are a victim of fraud, let's say every other day or every month, every 6 months, then you won't be getting any compensation. This is only once in your customer's lifetime. Okay, but 85% would be the loss amount which would be given to you, provided your gross loss cannot be more than 50,000 rupees. Okay, now what is the reporting requirements? The reporting requirement is that you have to report the fraud to the National Cyber Crime Reporting Portal. You can call this helpline also, or just call the concerned bank. Let them know that you have been a victim of a fraud. In that case, if you do so in the next 5 calendar days, okay, so if you do it in the next 5 days, then from the occurrence of the fraudulent transaction, then you are eligible to get the compensation under the scheme. Okay, so this is now the new way in which you get some compensation, digital compensation, for any kind of fraud which has taken place. Okay, so yes, these were the news headlines for today. I know it was a very long, at least I felt it was a very long news analysis, because some very important, some very detailed topics we had covered. Okay, now it is time to go into the 21 GK questions. So again, the usual 5 questions at once, we are going to discuss those 5 then, and then we'll move to the next set of 5 questions, and then finally there is one bonus question also, okay, with some very important information. Okay, sir, sorry, I'm late. Sorry, it's okay. Sorry, sir, it's okay. Someone married, it's totally all right. You can watch the recorded lecture also. But let's see, someone, if you can now answer these questions or not. Okay, that would be a good check for you. Okay, so now let's discuss the first one. Right. FCRA वाले में I felt sleepy. I know it's very mentally tiring, these topics today. Okay, I'll try to balance the topics. I should have taken FCRA in tomorrow's class. I think that would have been better, right? Anyway, so let's discuss the first one. Samvidhan Hatya Divas is observed every year on 25th June, 12th July, 26th January, 15th of August. Next, Indira Gandhi contested the 71 Lok Sabha elections from which constituency? So that was the election which was declared void by the High Court. Okay, she contested from Amethi, Allahabad, Rai Bareli or Lucknow. Third, which court invalidated Indira Gandhi election in 75? Was it the Supreme Court, Bombay, Delhi or Allahabad High Court? Fourth, the 75 emergency was proclaimed on the grounds of, what was the ground of the 75 emergency? And the fifth one, who proclaimed the national emergency in 1975? Okay, so it is simply asking you who was the president at that time. Okay, so let's see if you have been able to answer the first one. Yes, all of you have answered the first one correctly. So first answer is A. Okay, so some of you are new to this class. So how do you answer it? So first you give the number and then tell me the option. If it is 1A is the correct one, write 1A. Okay, for similarly, it's second. If I look at the second one, Indira Gandhi contested the 71 election from which constituency? From Rai Bareli. So you have to answer 2C. And I see all of you have given the right answer. Third ka you have answered as everyone has answered A, which is also correct. So yes, third ka answer is A. If we look at the fourth one, the 1975 emergency was proclaimed on the ground of internal disturbance, which is no more a ground now. So fourth ka answer D ho jayega. You have given the right answer. And fifth ka you have answered as C, which is also correct. Fakhruddin Ali Ahmed was the president of India when emergency was imposed. Okay, now let's look at the next 5 questions. Which constitutional amendment replaced the term internal disturbance with armed rebellion? Okay, which was the constitutional amendment which did so? Seventh, which case expanded the scope of Article 21 and held that the procedure established by law must be fair, just and reasonable. Okay, so some important case laws you can remember for legal GK also. So for that purpose, I have introduced this specific question also. Okay, so what would be the answer to 7th now? 8th, which of the following years did not witness a proclamation of national emergency in India? Interesting question here. Okay, so you have to tell me which of the following was not the year when national emergency was imposed. Okay, so obviously 3 would be correct, 1 would be wrong. Well, 3 are the years when emergency was imposed, and you have to tell me in which year it was not imposed. 9th, statement based question. I am sure you would be able to do it correctly. First is, a national emergency can be imposed in the whole of India or only a part of India. Once approved, a national emergency automatically expires after 6 months and cannot be extended. Which of the following statement is correct? And 10, which of the following is not a mode of acquiring Indian citizenship under the Citizenship Act of 1955? Okay, so very easy question, I would say. But let's discuss the 6th one. What you have answered for 6? You have answered 6th ka as A, which is correct. It is 44th Constitutional Amendment Act. If we look at the 7th, which case expanded? 7th ka you have marked as C, which is also correct. It was the Maneka Gandhi case where the court said that your Article 21 procedure established by law means that the law should also be just, fair and reasonable. 8th ka you have said it is D, which is correct. Okay, 8th का is D, which is the correct one. ठीक है, 8th का D होगा 78, 62 India China War, 71 India Pakistan War, Bangladesh Liberation War, and 75 the national emergency on internal disturbance. Okay, 9th का you have answered as A, which is correct. A, this is a correct statement. This is wrong because once approved, our national emergency does not expire after 6 months. Okay, it continues for 6 months. If it is reapproved, then it can again be extended also. So 9th answer will be A, and 10th answer you have mentioned as B, which is correct. Okay, now let's look at the next set of 5 questions. Which document is issued by the government to a person who acquires citizenship through registration or naturalization? Okay, so which document is issued for a person getting citizenship through registration or naturalization? Domicile, Aadhaar, passport, certificate. 12th, minor children of Indian citizens may acquire Indian citizenship by registration. Is it correct or not? Person married to Indian citizens may be eligible for citizenship by registration. Is it correct or not? Okay, let's see if you can answer these. 13th, consider the following statement. Aadhaar card is proof of citizenship in India. Aadhaar card serves as proof of identity and residence. 14th, FCRA is administered by which of the following ministry? So FCRA comes under which ministry now? Is it Home Affairs, Corporate Affairs, Finance, or Law and Justice? And 15th ka answer. 15th, let's see if you can answer 15th. The minimum penalty prescribed under the revised FCRA penalty framework for most violation is 25,000, 50,000, 75,000 or 1 lakh. So what is the minimum penalty? Okay, so let's see if you can answer 11th. 11th ka you have answered as D, which is correct. Yes. 12th ka you have answered as C. Both are correct, which means iska bhi 12th ka sahi diya aapne, both 1 and 2. 13 देखते हैं हम. 13th का आधार कार्ड इज प्रूफ ऑफ सिटीजनशिप इन इंडिया. दिस इज फॉल्स. इज प्रूफ ऑफ आइडेंटिटी. दिस इज ट्रू. तो 13th का आंसर इज B, which is correct. Good. 14 देखते हैं. FCRA is administered by which of the following ministry? 14 का you have answered as A, which is correct. 15 का okay, yes, 15 का answer is not A, it is D. Okay, so in FCRA the minimum penalty is 1 lakh. It's okay, Devansh. 16 पे आते हैं. Which ministry has announced the introduction of index of service production? 16 का आंसर बताना आपको. 17. What is the base year adopted for ISP now? What is the base year? 21, 22, 22, 23, 23, 24 or 24, 25. 18th. The technical advisory committee that developed the ISP was headed by whom? So who headed the TAC that developed the ISP? Arvind Virmani, Devjani Ghosh, BVR Subramaniam or Amitabh Kant? 9th. Under RBI's new digital fraud compensation framework, compensation is available only if the gross loss due to a fraudulent electronic banking transaction is up to what amount? Okay. 20th. The compensation benefit under RBI's new digital fraud compensation framework may be availed once every year, once every 5 years, twice during a customer's lifetime, or once during a customer's lifetime. Okay. And the bonus question, which is very, very important for you, and it can be a very important source material for you also. The question is, under RBI's new digital fraud compensation framework, victims of digital payment fraud must report the incident through the National Cybercrime Helpline. What is the helpline number? Okay, so you have to answer that which of the following is the helpline number, okay, for your National Cybercrime Helpline. But at the same time, all the 4 numbers are national official helpline numbers for different services provided in India. So try to find out what these helpline numbers are for. Okay, and if possible, mention it in the comment box once you have find it out. Okay, so once the video ends, then in the comment box you can answer 1930, 1098, 112 and 181. They are official numbers of helpline numbers for which ministries or for what purposes. Okay, let's see. Sir, I'm in class 11, so ask me a best novel for reading for CLAT. अगर if you are asking me novel, I would say कि भाई आप World Power Made Easy कर लीजिए पहले. Do that book if you have done it, then only move to some other novel. 16th का your answer is A, which is correct, Ministry of Statistics. 17th. What is the base year adopted for the index of services production? 17th का you have answered as D, which is correct. 18th का you have answered as C, which is also correct. 19th का आपने आंसर दिया है as one of you has answered B, one has answered A. The answer is B. ठीक है, gross amount is 50,000. The upper limit of loss is 25,000. Okay, but your loss should be around 50,000, not more than that. 20th का answer is D, which is correct. And 21st का आंसर आपने दिया है A, which is also correct. Yes, तो National Cyber Crime Helpline is 1930. ठीक है. Then you say 1098 is your women helpline, which is not correct. 1098 is your child helpline. Okay, it is 181 जो है women helpline. And this 112 is like the 911 of US. If you have seen some English show, US show or movie, there you would have seen कि 911 is their emergency number. So similarly, 112 is your all-in-one emergency helpline. All-in-one emergency helpline number of India is this. Okay, so if you want to call police, fire brigade, okay, etc. So you get this single number. Ambulance if you want to call, so you can dial this one number, 112. Okay, so yes, these were the answers. So Saman Mehra, I hope you have your answer now. Start with your word power made easy by Norman Louis. Start solving it if you are in 11th class. That is the best time to start your word power made easy. Okay, in case you still have any question, any doubt, you can always ask in the comment box. And in case of, please, any comment feedback is there, just mention it in the comment box. We'll try to use it or do it in the next news analysis and other videos. Okay, okay, so that's it from my side. Thank you and have a very nice day.